The European Union's employment strategy dates back to 1997. This strategy has established a set of common objectives for employment policy and contributed to soft coordination among the member states through a monitoring process. Creating more and better jobs was one of the main goals of the European 2020 strategy. The Commission has proposed new and more ambitious targets in the areas of employment, skills, and social protection in order to build a strong social Europe by 2030. The EU merely sets minimum standards in the field of employment policy in view that employment policy is still largely within the remit of the member states, therefore the national governments. I wish also to mention Article 8 of the Treaty on the Functioning of the European Union, which stipulates that in all of its activities, the European Union shall aim to eliminate inequalities and to promote equality between men and women. This article has also been applied to employment law. Furthermore, Article 9 of the Treaty on the Functioning of the European Union states that in defining and implementing its policies and activities, it is referring to not just to employment policy but to all policies of the European Union, the European Union shall take into account requirements linked to the promotion of a high level of employment, the guarantee of adequate social protection, the fight against social exclusion, and the high level of education, training, and protection of human health. Again, this Article 9 has also been applied to employment law. Finally, Article 10 states that in defining and implementing the policies and activities, the European Union shall aim to combat discrimination based on sex, racial or ethnic origin, religion or belief, disability, age, or sexual orientation. Once again, Article 10 has been applied to the development of the EU's employment policy. Now, some rights and benefits which have accrued to European workers include the improvement of their social and economic situation through better rights and better rules. Today, the European employee has better conditions of work and better pay, and also there is an improvement in his work-life balance situation through the Work-Life Balance Directive. Other rights include equality at the workplace, the protection of human health at the workplace, and the fight against social exclusion and discrimination at the workplace. Now, I will give a short overview of the rights and benefits that European workers are benefiting from through a number of subsidiary legislation of the European Union. At the level of individual labor law, there is the Directive 89/391 EEC on the improvements of health and safety of workers at the workplace. Another directive, Directive 2003/88/EC, concerns certain aspects of the organization of working time. Another directive, 1999/70/EC, is dedicated to fixed-term work contracts. Other directives include the protection afforded to workers who work part-time. The same applies to the protection with respect to temporary agency work. Now, with respect to collective labor law, there are dedicated directives with respect to collective redundancies, namely the rules which apply when there is a collective redundancy at the workplace. There is also another directive on the safeguarding of the employees' rights in the event of transfer of undertakings, businesses or parts of undertakings or businesses. And also there is a directive, Directive 2008/94/EC, which speaks on the rights of workers in the event of an insolvency of their employer. Other related directives are directives on equality law, such as the Equal Treatment in Employment and Occupation Directive 2000/78/EC. Other directives concern the equal treatment between persons irrespective of racial or ethnic origin. A rather also recent directive also affords necessary protection to workers who are posted in the framework of the provision of services. An important development with respect to the European Union's employment law is the Community Charter of Fundamental Social Rights of 1989. This Community Charter of Fundamental Social Rights was supplemented by an action program of the Commission, adopted also in 1989. While the Community Charter was not a legally binding act, it was nonetheless of considerable importance for the legal developments of the following years. The Maastricht Treaty, for instance, agreed on the Social Policy Protocol 1992, which provided for additional competencies in the field of social policy and thus allowed for the implementation of the Charter. Apart from the expansion of competencies, the Social Policy Protocol also provided for a simplified legislative process as well as for the involvement of social partners by means of consultation and institutionalized social dialogue. Now, with respect to the Social Policy Protocol, this has introduced the possibility for the social partners to contribute directly to community legislation by means of framework agreements. An example are the European Works Council Directive, the Parental Leave Directive, the Work Balance Directive, and the Part-Time Directive. All these directives were enacted on the basis of the Social Policy Protocol. Now, the Amsterdam Treaty of 1992 also made a significant change with respect to employment law. The Amsterdam Treaty also introduced a new competence referred to as action to combat discrimination, namely Article 19 of the Treaty on the Functioning of the European Union. The Nice Treaty of the year 2000 also brought developments with respect to employment law in the sense that it reordered and expanded the competencies pursuant to Article 151 and 153 of the Treaty on the Functioning of the European Union. It also brought about the Charter of Fundamental Rights of the European Union.